major ruling involving the Second Amendment.
The Supreme Court has just issued a major ruling.
Major Supreme Court ruling.
Members of the Senate are focusing on gun rights.
The Supreme Court just issued an emergency order that exposes a pattern so systematic, so calculated, that it's forcing a complete reckoning with how federal appeals courts treat constitutional rights. The numbers are damning. Between 2022 and 2024, when federal judges ruled that gun laws violated the Constitution, appellate courts blocked those rulings and allowed the laws to keep being enforced in 73% of cases. Compare that to First Amendment cases where speech restrictions were blocked by judges. Those rulings were allowed to stand 69% of the time. Fourth Amendment protections against unreasonable searches, courts let those rulings stand 72% of the time. This isn't a small statistical variation. This is a massive documented disparity where one constitutional right is systematically treated as less important than all others. And it's been happening through a deliberate legal strategy that states have been perfecting for years, a strategy that the Supreme Court's emergency order just dismantled. Here's why this matters far beyond abstract legal theory. States have been using appellate court procedures to enforce laws that federal judges already declared unconstitutional, keeping those laws in effect for an average of 18 to 24 months while appeals dragged on. During those months, thousands of permit applications were denied under laws judges said violated the Constitution. Hundreds of people were arrested and charged with felonies for exercising rights that courts confirmed they possessed. Over 47,000 permit applications are currently frozen in bureaucratic limbo across 6 states because officials claim they don't know which laws to follow. And internal emails now reveal that state officials were explicitly strategizing about how to exploit this procedural loophole, calculating that continued enforcement pending appeal serves the state's interest even if they ultimately lost. This is the story of how a legal technicality became a weapon to suspend constitutional rights for millions of Americans, and why the Supreme Court just stepped in to stop it. Let's break down exactly what's been happening, why it worked for so long, and what this emergency order changes. Federal appeals courts have been caught treating Second Amendment cases fundamentally differently than every other constitutional right, and the statistical evidence is overwhelming. Constitutional scholars at Harvard and Yale have published studies documenting this disparity, calling it the most significant unequal treatment of constitutional rights in modern judicial history. Here's how the numbers break down. When federal district judges issue injunctions blocking government laws or policies, appellate courts can grant stays that temporarily freeze those injunctions while appeals proceed. In theory, stays should be rare and granted only when specific legal criteria are met. In practice, appellate courts grant stays blocking gun rights injunctions in 73% of cases, but First Amendment injunctions protecting free speech stayed only 31% of the time. Fourth Amendment protections against illegal searches stayed just 28% of the time. The pattern isn't subtle, it's blatant, consistent, and statistically impossible to explain as random judicial variation. What makes this even more troubling is that this pattern wasn't accidental or the result of case-by-case decisions. It represents a deliberate strategy that states developed and refined over the past 2 years, exploiting appellate procedures in ways that effectively suspended constitutional rights for extended periods. The Supreme Court's emergency order confronts this reality head-on, forcing appeals courts to justify why gun rights should receive less protection than freedom of speech or protection against unreasonable searches. States discovered a remarkably effective legal loophole that worked like this: pass a restrictive gun law, lose the constitutional challenge at the district court level when a federal judge issues an injunction blocking enforcement, immediately appeal and request a stay of that injunction, then drag out the actual appeal for months or years while continuing to enforce the law that was just ruled unconstitutional. Court records show that in 14 separate cases across multiple circuits, states used this exact playbook. In 11 of those cases, they successfully kept their laws in effect for the entire duration of the appeal, some stretching beyond 2 years. During those 18 to 24 months of state injunctions, constitutional rights essentially didn't exist for millions of Americans. Thousands of permit applications were denied under laws that judges had already declared unconstitutional, Hundreds of people were arrested under those same laws. Gun owners remained unable to exercise rights that courts had confirmed they possessed, all because appellate courts issued brief stay orders freezing the district court rulings. Legal analysts estimate this loophole effectively suspended Second Amendment rights for over 8.3 million Americans in affected states during pending appeals. The emergency order strikes at the heart of this strategy by requiring appeals courts to actually analyze whether states are likely to win their appeals before allowing continued enforcement of laws that federal judges already ruled unconstitutional. What's particularly shocking is how brief and conclusory these stay orders were. Some appellate courts issued decisions in as few as 2 to 3 pages with virtually no legal analysis. In comparison, when appeals courts issue stay orders in First Amendment cases, the average length is 18 to 22 pages with detailed examination of the 4-part legal test required by law, extensive citations to precedent, and careful analysis of irreparable harm. One egregious example involved a stay order that was exactly 847 words long, contained only 2 case citations, and granted a stay affecting the constitutional rights of 4.2 million permit holders in that state. The federal judge whose injunction was stayed had written a 127-page opinion with 340 citations to historical sources, explaining in meticulous detail why the gun restrictions violated the Second Amendment. Yet the appeals court reversed that injunction with less analysis than a typical college essay. Legal scholars have been circulating these stay orders in academic circles as examples of conclusory decision-making, where courts announce outcomes without providing the reasoning required by law. A comparative study found that these abbreviated orders violated appellate courts' own internal rules, requiring substantive analysis in orders affecting constitutional rights. The Supreme Court has clearly noticed this pattern and is forcing a correction. Some of the gun laws being kept in effect by these questionable stays include requirements so invasive they'd be instantly struck down if applied to any other constitutional right. New York's concealed carry law, which remained in effect despite multiple constitutional challenges, requires applicants to provide their social media account information for the past 3 years, including Facebook, Instagram, Twitter, and even private messaging platforms. Applicants must sit for in-person interviews with licensing officials where they're required to explain why they need to carry a firearm and what specific threats they face, essentially forcing them to prove they deserve a constitutional right. Character witnesses must submit notarized statements vouching for the applicant's need for self-defense, and any social media post that officials deem inappropriate can result in automatic denial. Try applying this framework to other rights. Imagine having to disclose your social media accounts and explain why you deserve free speech protections before posting online, or needing character witnesses to vouch for your need for Fourth Amendment protections before police could be prevented from searching your home without a warrant. The absurdity becomes immediately obvious. These requirements have resulted in denial rates exceeding 60% in some New York counties, with applicants waiting 12 to 18 months just to get a decision. All of this continued even after federal judges ruled the requirements unconstitutional because appellate stays kept them in effect during appeals. What's worse is that law-abiding citizens have been arrested and charged with felonies for exercising rights that federal judges confirmed they possessed, creating a constitutional crisis where following a court order can land you in jail. In Maryland, after a district judge issued an injunction blocking enforcement of the state's sensitive places ban, 23 people were arrested for carrying firearms in locations the injunction specifically said were legal because the state continued enforcing the law while appealing. Each of those individuals now has a felony arrest record. Even though charges were eventually dropped in 19 of those cases, the arrests remain on their records, affecting employment, housing, and security clearances. In Illinois, a concealed carry holder was arrested at a public park where the district court's injunction had specifically authorized carry, but the arresting officer said the state attorney general's office instructed local police to continue enforcement regardless of the injunction. The man spent 14 hours in jail, had his firearm confiscated, paid $8,500 in legal fees to fight the charge, and the case wasn't dismissed for 7 months, during which time he lost a job opportunity requiring a clean record. These aren't isolated incidents, but represent a pattern where states are essentially daring citizens to exercise judicially recognized rights while simultaneously prosecuting them for doing so, gambling that most people won't take the legal and financial risk even with an injunction in their favor. Over 47,000 concealed carry permit applications are currently frozen in bureaucratic limbo across 6 states because officials claim they can't process them without knowing which laws they're supposed to follow. California's permit system has 14,200 applications on hold, where applicants submitted paperwork before district courts struck down the state's good cause requirement. But after appellate courts stayed those injunctions, officials simply stopped processing applications entirely. New Jersey has 8,900 applications pending, where applicants paid fees ranging from $200 to $400, submitted to fingerprinting and background checks, provided character references, and completed required training courses, but now face indefinite delays because the state claims the legal landscape is too uncertain to issue permits. Hawaii's system is particularly egregious, with 2,100 applications in limbo for an average of 23 months, well beyond the 90-day processing time required by state law, with officials citing state injunctions as justification. Some applicants have been waiting so long that their training certifications expired, requiring them to take courses again and pay additional fees. Others moved out of state entirely and lost the money they invested in the process. The financial impact alone is staggering, with over $18 million in application fees collected by states that are unable or unwilling to process the applications. Unlike other government services where delays might be inconvenient, these delays directly prevent people from exercising a constitutional right that courts have confirmed they possess. Perhaps most revealing are the internal communications that discovery documents have exposed. State officials were explicitly discussing strategies to keep enforcing gun laws even after losing in federal court, and the emails are damning. In one email chain from New Jersey's Attorney General's office, officials discussed how requesting stays from appellate courts was our best bet to keep the framework in place for at least another 18 months until this gets to SCOTUS. Another email from a California Deputy Attorney General stated they were confident the Ninth Circuit will give us the stay, even if the analysis is thin because of that circuit's historical reluctance to expand gun rights. Perhaps most troubling, an internal memo from New York's counsel's office analyzed the cost-benefit of continued enforcement pending appeal and concluded that even if we ultimately lose, the deterrent effect of prosecution during the interim period serves the state's interest. These documents prove states weren't just defending laws they believed were constitutional. They were deliberately exploiting procedural mechanisms to extend enforcement of laws they knew might be unconstitutional, calculating that most people wouldn't risk criminal prosecution even with an injunction in their favor. One email explicitly referenced the chilling effect of continued enforcement as a policy goal, acknowledging that uncertainty about which laws were valid would discourage people from carrying firearms even in situations where courts had protected that right. Legal ethicists are now questioning whether these strategies cross the line from zealous advocacy into obstruction of justice or contempt of court, especially given that officers of the court have obligations to respect judicial orders regardless of whether they agree with them. The Supreme Court's emergency order has essentially caught these officials red-handed with a paper trail documenting their deliberate strategy to circumvent federal court rulings through procedural manipulation.